Hey, good evening, everyone. Dawn Zoldai here, the host of Inner Drones at Dawn podcast. But tonight we're here with you with Drones at Dusk. Yes, when you wake up and you see there's been a remote ID lawsuit filed first thing in the morning, you call up Inner Drone and say, we got to do something on this. And then you call the guys that are involved and you say, hey, will you answer some questions about this? So here we are. This is a special podcast. And this is live, so welcome, and please ask your questions in the chat. Positivity is what we're looking for, encouragement, all goodness here. So thanks again for being here. And once again, I'm pleased to have with us the two gentlemen involved in this case, Tyler Brennan and Jonathan Rupprecht. We also have Mike Pahel here from Inner Drone, our fearless leader, who whipped this thing up in almost record time. So pretty amazing. So first, let's go ahead and do some intros for those that don't know you guys. So go ahead, Tyler, over to you.
Hello, guys. My name is Tyler Brennan. I am because I know you're wondering, I'm the 27-year-old owner of Race Day Quads. Founded it in 2016, and today we are one of the world's leading first-person view drone distributors and e-commerce companies. We're based out of Orlando, Florida, with 30 employees, and we are leading the FAA case that we're discussing today.
Well, that's awesome. And Tyler, we have probably a good mix of people in the audience. So I'm just going to ask you right up front, can you explain what first person view is for those that may not know it? Most people probably do, but just in case.
Yeah, absolutely. So first person view is, I guess in the drone world, at least, it is when you throw a camera on your drone and then you see what the drone sees in real time and you fly via that camera. So that is first person view, and there's a number of ways to do it. The way that we do it most of the time as FPV hobbyists is via goggles. So it's a very immersive experience. But on the commercial side, you'll see readily a bunch of applications where you're viewing large monitors, and it's less of an immersion and more of a, you can look at your FPV camera for whatever reason, and then also be able to look at the photography drone or mapping drone or whatever it is.
Awesome. Thanks for clarifying that, because that FPV is at the heart of this case, right? And the hobby that you're speaking of. So we'll get to that in a second. Jonathan, could you please introduce yourself?
Sure. I'm Jonathan Rupprecht. I'm a commercial pilot, flight instructor, and I'm a drone attorney.
That was short but sweet. For an attorney, I mean, that's amazing. And most everybody here probably already knows Mike, but Mike, if you want to just go ahead and give yourself a shout out, that'd be great.
Yeah, so I'm chair of Interdrone, 3 years running, been with the show for 6 years. Excited to hear from the plaintiff here, see what the perspective is, and then see if you're giving voice to a certain constituency in the hobby lobby of the drone industry.
Yeah, I feel like I should have had, my lace collar on, like Ruth Bader Ginsburg, but, talking about lawsuits and all that. All right, so let's get to it. Lawsuit. Several years in the making, right? And Tyler, can you give us some background and context, when this started bubbling for you?
Yeah, absolutely. So the NPRM that kind of caused all the uproar, and of course, I believe it was Congress that said, hey, FAA, you have to make a way to integrate UAS into the airspace. Jonathan, correct me if I'm wrong, but I recall that being in 2016. My company was just getting started in 2016, so it was not even on my radar. But fast forward to the late December of 2019, and the NPRM notice of proposed rulemaking comes out from the FAA with regards to remote ID. As far as the first-person view hobbyist side was concerned, it was basically a no-go in that there were multiple issues in there that would essentially not allow FPV to continue as it was today. So that is what kind of got the ball rolling on this. And the FPV community is pretty large, and we're very passionate. And there has been a number of initiatives that have launched to try and combat or give our case or try to create a better outcome for us. And one of those was the legal front, which I felt I've been very lucky in that I was in a position where I could help lead that for our community. And so this is just the legal case is just one of the many things, but ultimately because we felt that we were not adequately heard or accounted for in the FAA rule that was put out.
Okay, awesome. There's a lot to peel back there, so I'm going to walk it back a little bit. You talked about the 2019 Notice of Public Rulemaking, or NPRM. For those that aren't very familiar with it, maybe some of you are, but it's a little bit of ancient history now because we've got the final rule out. But at the time, right, the FAA had proposed this remote identification. The idea was, hey, let's give law enforcement, security agencies access to information so that they can protect the security of the national airspace, right? Our national security. And the idea was, if you have this remote license plate, they can then triangulate these message elements that would be beamed out of the aircraft. And those things, those evolved over time, but they were like the location of the operator, right? The location of the drone and the speed of the drone and things like that. There was going to be a network and a broadcast solution. The network at one was called Standard ID, Remote ID, and that was with both. And then the other was Limited Remote ID. That was going to be network only and fly within 400 feet and all these things. But for the hobbyists, even from day one, as you mentioned, right, they were going to be relegated to flying in a federally recognized identification area, or a FRIA, if they didn't have the remote ID capability on board. Is that about right, Jonathan? Did I do a decent job of summarizing kind of where we were in 2019?
Yeah, pretty much. Yeah, limited network or FRIA, or anything that was under pretty much like sub 250 grams. That was pretty much it.
Yeah. So Tyler, you said there were things about that would have hamstrung, your community, your FPV community. What exactly in that notice, the original notice, was causing you concern?
Oh, geez. There were quite a number of things. For us, mainly, I would say the main sticking points were that it had to be as it came from a manufacturer. Most of what we do is you buy the parts, you pick out your parts, you build it yourself, you go fly it. That would not have been allowed under the NPRM. And then the fact that you had to have a kind of an enclosed or all-in-one flight controller with this module, that definitely, unless it was made by someone in an FPV who is very, very, very good at what they did, which it probably would not be, it would not fit in our drones. And then you had to connect to a network, which is not going to be good for, hey, you want to go fly up the side of a mountain or, do anything that is outside of a network. So because of that, it was pretty much the feeling like, hey, we're just not going to be able to fly like we are, at least.
Okay, and tell me about the FRIA aspect of this, the federally recognized identification area. Was that causing you concern?
Yeah, so a lot of those were going to be, to my understanding, were going to be AMA fields, essentially, if we boil it down that way. And FPV drones and AMA fields do not exactly go hand in hand, do not go together. There's been a lot of examples of kind of the model aviation guys, not wanting the FPV guys there, and it's just been a tough mating there. Additionally, most of the fun that's in FPV you could not go get in an open field. Just the thrill, the immersion of it is just not possible in an open field because there's no thrill or excitement there. It's a lot more different. Like, I come from the world of like large gas powered airplanes, and that's what I did before FPV. And so I've experienced both sides. I can confidently say that a 99% of FRIA fields or AMA fields would be of little to no use to the FPV pilot.
Okay, and again, I'm not going to assume everybody knows this, but where is that excitement, and where do you prefer to fly?
Yeah, sure. So everyone kind of has their own preferences, but by and large, People enjoy flying at local parks, through woods, at race courses that they set up, in their own backyard. So that's the big difference between model aviation and FPV. Is FPV, I can set up my drone in my garage and go fly around my backyard and have an absolute blast doing so, while staying on my property the whole time. Not really possible with an RC model plane.
So understandable why the notice of public rulemaking would have caused you some concern. And so at some point, enter Jonathan. So how did you get involved, Jonathan, with Tyler?
He reached out to me and we started talking.
All right. And shortly thereafter, if memory serves, Tyler, you started a GoFundMe page for potential, legal fees or, for a lawsuit. So tell us a little bit how that came about.
Yeah, absolutely. So when I got with Jonathan and we discussed it, like, hey, can you look at this? Do we have anything here that we could go after? And Jonathan was like, oh, yes, we got a lot we can go after. And so, all right, cool. So then what I did was I reached out. We have a very, very, like I said, very tight-knit group, very passionate group. And so I reached out to my Facebook page. And I made a post essentially saying, hey, guys, I know everyone's like, we're pretty high strung about this whole NPRM thing right now. I want you to know that we intend on challenging this legally if the final rule doesn't come out in a way that's favorable to hobbyists. And so then I have never seen anything like this, but within about 24 hours, it was everywhere in the FPV community. And everyone was talking about it, and word spread like wildfire. And our support team the next day at Race Day Quads was quite literally having a very difficult time doing their job because we were getting so many emails and so many requests. People messaging me personally and commenting on the posts I made and all this, requesting on, hey, how can I help? How can I donate? So on and so forth. My initial reaction was, it's way too soon. Like I haven't spent anything yet. We haven't done anything yet. Like I'm just telling you guys this is what we plan on doing. But nonetheless, the reaction was such that we ended up making a page. And so that page was made in like March of 2020. So almost a full year now. And as of this morning, we're just north of about $41,000 in donations from 850 plus donors. So, and those donors have not just come from FPV, they've come from everywhere on the hobby and commercial side. I've everything from a high school rocket club to normal model aviators, and then of course your FPV, and not just from the United States, but all around the world. We've received donations.
That's amazing.
What's it like being a tuning fork for what seems like a rising sentiment? And I mean, how do you kind of put yourself in perspective having to take in all that energy from the community? Did your perspective kind of change in the course of seeing how much support you had?
Yeah, so I mean, like, one of the reasons that we've had the success that we've had is because I've always viewed myself as a pilot. I'm just one of the guys, and if I'm going to go offer something in my store, it's because that's what I want as a pilot, and therefore that's what a lot of the other pilots want. But something that did affect my perspective, like you're talking about, is when these donations start coming in from a lot of places outside of FPV. So I started off very, very narrowly focused, and I still am focused on the FPV community, but it's become very clear to me since that this doesn't just affect FPV. This affects absolutely everyone that is going to be in any way touched by this, which is pretty much anyone that flies anything, remotely. So it's a tall task, and it hasn't all been 100% positive, but most of it has. And so I'm just excited and happy and grateful that I'm in a position where I can feel like I'm actually doing something, and allow all the people that feel the same way to pitch in. So it's really a true community effort.
Well, your kickoff of your GoFundMe page really corresponded, it sounds like, with the closure of the comment period for the notice of public rulemaking, because I believe that closed on March 2nd of 2020. The FAA received like 53,000 comments to that initial rule. So I'm going to punt this one over to you, Jonathan. Can you educate folks a little bit on that process, the Administrative Procedures Act, and how this is all supposed to flow, because it is relevant to what you're doing now?
Right. So here in the United States, we're all under the law, including the FAA. You can't just go and make things up and do things. And so the FAA has basically Congress told them, as well as all the federal agencies, through the Administrative Procedures Act, on how to actually create regulations. And so basically what's kind of normally referred to as just like notice and comment. So they put out a notice in the Federal Register of a proposed rule. We get to review it. And then the comments that are submitted, the agency looks at them and then has to respond to the significant comments. And then they put out a final rule. In the final rule, there's the actual regulations, but there's also what's called in like the preamble, which explains, hey, somebody said this, and here's our response to that, or why we didn't do this this alternative suggestion from such and such a person. And that's really what the Administrative Procedures Act is. In a nutshell. And there's a few times where you can comment one at the when it was at the comment stage with at regulations.gov, and that's where 53,000 people commented. But you could also comment through OIRA, the Office of Information Regulatory Affairs over in White House, when they were actually reviewing the final rule. So Tyler actually found out about some of these this information prior to, especially. We'll get into a little bit later on ex parte, but Tyler actually met with DOT and FAA and OIRA. I don't know, Tyler, you want to tell them about that to try to explain that some of what they were doing was improper?
Yeah, that sounds good.
No.
So you start you're concerned about the rule, you start the GoFundMe, and then you start meeting with people. So tell us about that, Tyler.
Yeah, I mean, Jonathan, thanks for pushing me over there. Jonathan helped me set that up and was like, hey buddy, here's some people you need to talk to and kind of voice some of the concerns that we're having here and enlighten them on some of the issues from a regulatory perspective that we're seeing. And so, of course it represented all my personal views, but with some good coaching from Jonathan, we had about a 30-minute or so meeting with the OIRA. And I'm not sure if that went too far, but it was good. There were representatives from multiple different agencies there who listened to some of the procedural errors that I brought up.
Okay, well, we got a little bit earlier into your concerns about the aircraft themselves and the at-home makers would not be able to comply with the rule. The Foia and how that's so constraining then for those hobbyists. What are these procedural irregularities that you're mentioning here that you were discussing with OIRA?
That's a great question, Jonathan. This meeting was
Phone a friend.
4 months ago. Jonathan, help me out.
Phone a friend.
So you had multiple ones, and so when you have with the Administrative Procedures Act, you have to put notice out that you're doing something. And so then the comments are supposed to go into the comment area so we can all read what everybody else has to say. So you can go read what Tyler said, because Tyler put out some comments at that point, and you could see what everybody's saying. It's all designed to be very transparent and well ventilated, as the courts have kind of described it. But in parallel to that, we started noticing that there was stuff coming out that wasn't on the record in multiple instances. And we were like, well, that's kind of contrary to the law. And so we actually decided to bring that up so that way the DOT, FAA, and OIRA were on notice that this was all going on, and somebody could have thrown their hand up in there and said, hey, hold on a second, we should disclose all this stuff on the public record and give everybody to review it, get time to review it and actually comment further. But instead, the FAA chose to do a certain amount of stuff secretly, and then there was what we've commented on and what we got to see publicly on regulations.gov.
Okay, let's peel that back a little bit. So Jonathan, you and I have talked before, and my understanding is that while the rule was being reviewed, a cohort was created essentially, and this cohort involved these unmanned aircraft service suppliers, or USSs, that were going to be part of that original rule. They were the third party that those mission elements were going to go through. But none of that was publicly mentioned. Is that part of the concern that you're referring to?
Well, so the cohort was announced. They put out a solicitation, and there was an actual announcement that the 8 companies were selected. But this was all being done during the rulemaking process. And so what ended up happening is after the FAA announced those 8 companies, they ended up sending out another email a couple days later, basically trying to explain to everybody that, no, this isn't part of like the rulemaking. It's just something separate we're doing. But it was extremely confusing because everyone's like, wait a second, you're working on like rulemaking on remote ID, and you're doing this like cohort thing on network ID. Okay. And so that's what, and they ended up sending out an email to try to clean that up. In addition to the cohort, you also had like phase 2 of the unmanned aircraft pilot program was testing out remote ID up at the New Air up in New York. So you had also kind of some stuff, different places doing this, collaborating with the FAA on network ID while the rulemaking is going on. And none of the things that are being discussed, the documents the FAA is receiving, the documents that the FAA is sending out to these private companies, is being put onto a record for us to really fully understand. So there's kind of like 2 records here, right? There's the public record, and then there's what happens behind closed doors record.
You know, it's interesting that you mention this. I'm just thinking out loud now because, you know, the IPP was also going on at the time, right? The Integrated Pilot Program that had beyond visual line of sight and other operations possibly relevant to remote ID, and, you know, some testing and evaluation related to that. And in fact, the new Beyond program is doing the same. Are you saying that that research and development effort, to the extent that its purpose is to inform rulemaking, that the information from there needs to be publicly available and transparent? And part of that record?
Right, exactly. So, I mean, so the IPP, which later turned into the Beyond, that's a separate process from the UPP.
Yep.
So phase 2 of UPP was doing remote ID testing. And then you had the cohort of the 8 companies, such as like Airbus and AirMap and Amazon, T-Mobile. They were involved, and in that collaboration and in the MOUs that we discovered. So there's multiple 8 MOUs that were entered into, and I believe it was like the 2nd or 3rd week of January. So while the comment period was going on, the FAA was actively entering into agreements with these 8 companies to actively work on network identification. And when you look in the MOUs, you go, you know, what can you guys really work on? Is there something separate? And it's like, well, they're working on trying to work out the bugs and the problems on network identification. And you're like, well, what you're like trying to work out the kinks in the system prior to the final rule actually coming out, or in parallel, and you're not disclosing any of that on the record for us to actually kind of fully ventilate. Why is it we could actually maybe look at it and further elaborate on what was going on and say, actually, no, that technical issue you had or that legal issue you had over there, no, we could actually fix that. Here's our comments on that. But we don't know what that we don't know anything there because it was all kept in the dark. We only found out later on after the comment period was closed, which is why when I told Tyler about this, I said, you should probably go and contact OIR to primarily get them to also, when talking to DOT and FAA, that they should fully ventilate this and put everything out onto the record so everybody could comment on it, right? Aren't we all about transparency and due process of law here? But for some reason, people are getting creative and innovating contrary to law.
So I'm Mike, I know you're going to ask something. So
Yeah.
before you do, I'm very sensitive to acronyms, being a military and all that, former military. So MOU is a memorandum of understanding, and those are the agreements that the FAA basically entered in with these third-party uniform service suppliers. Just to clarify that. Mike, you were going to ask something?
Well, I'm just trying to get a better grasp on where the test sites and then companies like New Air, which work with the test sites, and then the services of New Air and the test sites are being used by these private companies, and how that all fits in with the FAA trying to collect data. So I think from your stance, what you're saying is that that process is not transparent enough in the first place, and then also if there is data that's been found, it's not on the public record.
If it informs the rulemaking.
Okay.
Right. So that's actually the real important point. It's not that there's something improper with them contracting and doing these type of specific vehicles. It's that at that period of time when the FAA is putting out the notice, that they're actually informing us of actually what's going on, and that especially there's some actual Department of Transportation regulations specifically directing FAA employees on how they should even interact with members of the public during this whole entire time. You can look it up at 49 CFR 5.19, where there's regulations on this so that it's fair and transparent. While at the same time, we have this innovation going on where that information is being exchanged between parties, but we don't know anything about that. That we could say there's a legal issue, or there's a technical or a legal solution, or a technical problem or a technical solution. It's about fairness and transparency here and following the rule of law at that time. That's the problem. It's at that time during the rulemaking, they did a lot of stuff ex parte.
So we'll talk about ex parte a little bit more, but just to, you're using the term, the fairness and the transparency and things like that. You talked about the Administrative Procedures Act, which is a statute, right? It's a law for those out there that are not lawyers. But at the heart, right, it's a constitutional issue. The APA exists because of the concept of due process, which comes from our Constitution, right, which requires notice and an opportunity to respond if you're impacting someone's life, liberty, or property. And there's a sliding scale there, and arguably this could be, right, a property issue. So that's why the Administrative Procedure Rule requires the notice. That's why you get the NRPM. Or the notice of public rulemaking, and have an opportunity to comment. So Scott Schofman looks like he just asked a great question. And Jonathan, over to you. I can look it up super quick. But what about Executive Order 12866 meetings? You tracking?
Yeah, the 12866 meetings. That's what. Because Scott, I appeared in one. I read his. And so Tyler was on, I read yours anyways, but that's what Tyler did, is he did a 12866 meeting. It's under Executive Order 12866, and you can meet over with people in OIRA and you give them your thoughts and opinions and views on things. So that's another option there if you kind of want to get a second bite at the apple in regards to commenting, which is why we chose that avenue post the comment period closing. And that's actually what got hilarious about the thing. Tyler, remember that email? I don't know if you want to tell me about the email that happened. Remember the whole FBI secret demo? Oh, let us know if you want to know any more information about it. You want to tell me about that, Tyler? What happened when you emailed them about it?
So wait a minute. Secret demos by the FBI. What are we talking about here?
Yeah. And were you invited? Dawn, were you invited? I didn't get an invite. Tyler
I want my invite now.
Nobody got an invite.
So what was this about? Do tell. Tyler, tell us what this demo was supposed to be about and how you found out.
Oh, you guys are killing me. This was, we Foia'd this, right, John?
Okay, so there was partially, yeah, after we found out about it, we ran with that. So Catherine Inman, who's also an FAA attorney, they ended up actually putting out a notice on the docket, basically saying that there was an FBI secret demo. And who was invited? You had all sorts of individuals that, from DOJ, federal entities, but you also had state, local law enforcement. You also had private entities such as NFL security. You had one trade organization that showed up. AMA wasn't there, AVSI wasn't there, and it's like, how in the world did this happen, right? And so after we saw that, we then we started investigating further. We filed some more Freedom of Information Act, and at that same time, Tyler sent over an email to them because the document that the FAA put out saying, hey, if you have any questions about this, email us at this email and we can talk about it. And so Tyler emails them and they come back with a statement going, we can't comment, during a pending rulemaking. And you're like, wait a second. So Tyler, you can't give any info to Tyler, but you can give info to all the people that you secretly invited to the FBI demo? Really? So cool kids, not cool kids. Certain people get invited to birthday parties, some don't. Anyways,
So
I'm not opinionated at all.
Was it literally like I'm words matter, and so I'm trying to understand, was it literally a classified secret meeting, or was it a meeting that just was non-public and
Right,
were
great,
not invited
excellent.
to the party?
Correct, excellent point. So I don't have any indication that it was any type of classification from secret or anything that would do that. However, I would argue NFL, drone responders. You also had one of the remote ID companies was there. And so you kind of go, I don't think those guys have TS clearances, or maybe not. So that wasn't public. So it wasn't like a security clearance issue. I'm referring to it as primarily just invite only, out of the public eye, until after the fact they published that in the Federal Register. But why wasn't, not the Federal Register, but the docket on regulations.gov, but why did they not publish all of the other information regarding the MOUs, the con-use document, regarding the overall plan of network ID? Why weren't they publishing any of that? They were selectively choosing certain things to make it look like they were trying to be transparent, but the real stuff they don't want us to know about, the MOUs and the con-use document, why do we have to go and get that via Foia? Why do we have to go and search around for that?
So that leads me to ask you two questions. Number one, con-use, can you explain?
Yeah, the documents, primarily it's a concept of use on how they were going to actually use the network ID. And so the overall idea was that these unmanned aircraft service suppliers would all be connected back to an FAA flight information management system. And then you could have different government agencies that could be able to connect to it and then query and watch in real time drone flights all over the place. And at this point, you should be kind of wondering, like, wait, that wasn't in the NPRM. Wait a second. They didn't explain this could just all be downstream to government entities who could just query the stuff or search through government the records of your flight logs. And so some people in the comments actually knew about some of this stuff and started raising these issues in the comments, specifically invoking certain cases like Jones, Carpenter, and Riley. And surprise, surprise, the FAA never responded to any of those in the preamble to the final rule.
So, Mike, keep me honest. Remind me to ask about the Fourth Amendment here in a second, but I have one question for Jonathan before that. And that is, you talked about the FOIA and having to use that vehicle to obtain all this information. So could you briefly explain to folks what the FOIA is and how not only you used it and Tyler used it, but how they could use it?
Sure. Yeah. The Freedom of Information Act is a law created primarily to allow U.S. citizens, really anybody, to have access to what's kind of going on in the government. There are certain exceptions, or called exemptions, from public, whenever you do a FOIA request, that the government can invoke and then either withhold a document in entirety or redact it. And then you can obtain it. And so there are some ways you can obtain stuff, provided that you can navigate the regulatory system. It's kind of annoying and difficult, and there's case law interpreting what certain exceptions mean and don't mean, but it's available to anybody to go and do that. And that was one of the mechanisms we actually used to go and find out about these documents, to actually get them out of the FAA. And I believe over on Tyler's website, there's at least one or two documents specifically. We obtained even certification documents from the FAA saying that those documents were accurate and true. So it's not just some made up PDF we're throwing up on the internet. I guess we could have made up the certification statement, but but we figured this would all go south at some point for them, and that we would have to probably bring stuff out potentially maybe later on in court. So that was some of the reasons why we started pursuing that early on after Tyler and I started talking.
How many FOIA requests approximately did you file?
I have no idea.
So that's a lot. So it's more than 10.
Yes.
Yeah, my understanding is that that's not
yeah.
easy to get that information. So this seems relatively timely, actually, that you were able to obtain documentation.
Yeah, well, so thankfully, like, Tyler reached out to me a while back, so we could kind of start, preparing for war. And the problem is when you can't do things quickly at a drop of a hat, especially with law-related legal issues, right? So that's why when Tyler reached out, I started searching around. We started figuring out parts and pieces and going, wait a second, there's this cohort going on. There's the UPP going on. We have the FBI secret demo thing that was published. And we ended up finding those documents. Funny enough, one of those documents that the FAA was sent out to everybody they made people sign a document basically saying that they wouldn't talk about it. So it's interesting. It's just transparency everywhere. And we had to get that via Foia too, by the way. So it's just something ironic. We use Foia. Every U.S. citizen can go and use it. I highly suggest people, if they're wanting to keep the government accountable, they should use it as well.
Okay, now Fourth Amendment. Okay, so I remember when the NPRM came out, just so many people throwing up red flags, privacy issues, Fourth Amendment. Some people are throwing out Fifth Amendment taking issues. You're gonna basically take my drone away from me unless I have to buy a whole bunch of new stuff to make it comply. People are raising the FISA, the Foreign Intelligence Surveillance Act, and all these other things. None of them knew at the time, and I wrote multiple articles. In fact, I wrote some for Interdrone. They're on my website if you want to check those out. Good times to go back and look at those again.
No, those are excellent ones. I mean, as far as understanding constitutional law, they're very clear language. Even a layman could understand them. So I recommend
what we didn't
every pilot
know,
reading.
so here's my question, Mike, to Jonathan. What we didn't know was this con use document that you're mentioning that says that law enforcement and security agencies will have real-time access all the time, anytime, without even reasonable suspicion necessarily to see flights on the FAA system. That's what that said.
Well, that was the concept of use. There is an important, I guess you would say, caveat in the sense that the FAA was the one primarily controlling how much access and restrictions and everything they could actually grant to the other agencies like DOJ and DHS and stuff. But even one of the examples was DOJ working on stuff where they can even allow state and local law enforcement having access through their USS. So then you could have federal USSs. And there was some info that we found out about DHS was working on that so that it would have access to it. So then the ability to primarily query and go back in time would primarily be based upon the parameters set in place by the FAA. The con use document is going to outline the overall architecture on how the overall system was working. And the NPRM primarily told us the FIMs on kind of up to the unmanned aircraft service suppliers, the public ones, the non-public, the civilian that we saw. But it didn't really fully explain all of these, like, oh yeah, hey, DHS really wants to kind of like query all this stuff and look at it in real time. We didn't see any of that in the NPRM, which would have even caused even more of more of a response. And then this all comes out in these meetings in DC with the cohort, right? And so none of it's on the record, and you're like, what's going on here, guys? And so I think in some of that, as they started going into it, I think they started realizing they were having a lot of issues with the Fourth Amendment, specifically like Jones, You have the Riley case with the cell phone tracking, and you have the Fourth Amendment being issues with Jones and with the GPS tracking device. And it's interesting to see how the FAA doesn't even respond to tracking in the final rule, right? Like, look up the word tracking and Fourth Amendment. You just really won't see much of a discussion on it. It's just like a bad word to them. It's just like, don't say that word. Don't tracking. No.
I'm like correcting everybody to explain what acronyms are, and there might be people out there that don't fully appreciate what the Fourth Amendment to the United States Constitution says. And basically it prohibits the government from engaging in unreasonable searches and seizures without probable cause, right? That requires normally a warrant based on probable cause, which is a reasonable belief, right? And issued by a neutral and detached magistrate. And so these are really, I think, Tyler, in your press release, you mentioned multiple constitutional issues. Is this one then, the Fourth Amendment, an issue that you had in mind when you put that in your press statement?
Yes. I'm sorry. I'm deflecting some to John here because we don't. I'm unsure of what what arguments exactly he is okay with us throwing out there to the public.
Understand? Yeah, this is sensitive. And,
Right.
and for people out in the audience too, I'm sure there's some people out there thinking, oh, this is really unbalanced. You don't have any FAA person here. Well, having worked for the government for 28 years, I will tell you they will not comment on ongoing litigation. So I could ask them to be here, they would not be here. And if I was a lawyer, I would tell them not to be here, quite frankly. So that's why they're not here. And that's why we have these two gentlemen without an FAA rep to defend their side of it. That's going to happen in the courtroom, and we'll talk a little bit more about that. There was a comment here, I think it's Scott again, saying some concerns about minors using drones as well that arose from the notice of public rulemaking.
Oh yeah, you're talking about like the
COPPA, is it the
COPPA
COPPA?
stuff? Yeah, the Child Online
Child
Protection
Online
Act stuff.
Yeah, Child Online Privacy and Protection Act. I did an article
whatever
on
that
too.
thing. Yeah. That was addressed. That is. Well, I guess what does Scott want me to say about that?
Well, it's an issue. You know what? Everybody go read my article. Yeah, I wrote about that thing. So go read it. There is a way, honestly, I just remember under that statute, which it's an online privacy act. So it's about the internet. It's really irrelevant under the final rule right now because the broadcast solution, maybe because it's not, I don't think it would qualify technically under the statute, the broadcast, but I'd have to think more on that. So let's fast forward to December 28th, the day that will live in infamy, 2020, when the FAA dropped the final rule, and it was officially published on January 15, 2021. Any surprises in there? I know what it said. I know the differences. I just did a piece for Inside Unmanned on that. But Tyler, what changed between that original notice and the final rule that surprised you, if anything?
Yeah, sure. So, I mean, personally, I was surprised, and I assume that a lot of the guys in our hobbyists were, in that it did not resemble, in my opinion, really much of anything that was in the NPRM, which is a kind of a disconnect and an issue that I'm sure John would love to elaborate on. But yeah, moving from a totally connected network idea with a bunch of restrictions in it to, oh, hey, no, now you just got to throw this module on your drone that's going to broadcast, some information. That was not, it did not seem like that was a logical A to B step for us. So instead, what we had to do was kind of dig in and really figure out, okay, what actually happened here, because obviously this is not what the FAA wanted originally. And so what we were able to infer from that and talking to some helpful individuals was that simply remote ID is not ready yet. It's coming. What they originally wanted to propose is something that they're still wanting to one day put into law, but it's just not ready yet. And so that's why we got this kind of final, quote unquote, final rule, which kind of probably surprised everyone except for those in the FAA. Because it just didn't resemble what was originally proposed.
Well,
so are you saying, go ahead, Mike.
Yeah, well, because, I mean, we've had guests over from Europe, and U-Space is going, full steam ahead with network ID. I'm just interested in, why does the pilot community actually care about network over broadcast? Because I've heard other cases where it's just kind of like, man, whatever, we get to move on. So from your kind of not little cohort, but your kind of section of the pilot community, why was network important to be in the rule?
Sure. Well, I mean, to be clear, if we had to pick, if we were forced to pick between one of the two, we would pick broadcast because it's less limiting, and we can fly it everywhere. Whereas in remote, you got to fly only in places you can connect, or else your drone won't take off. and then additional whatever fees there are with associated with having a remote module and connecting it and so on and so forth. So we would pick broadcast any day of the week. I feel like, but nonetheless, that doesn't make it okay in our opinion, which is why we are continuing on with the case.
So it's more about the shock of. Sorry, Don. So it's more about the shock of having one expectation of what was going to come out in the rule, and then it seemed like, and you aren't the only one to say this, that the rule was kind of divorced from all the prior steps that led to it. So you planning for your business, it gets interrupted.
Yeah, sure. Well, and I mean, it's a welcomed step. I think it was a step in the right direction, but that doesn't mean that we got all the way there. And it doesn't mean that, the original issue that I go back to on why are we doing this in the first place, which was FPV and hobbyists at large were not and are not listened to. So.
Yeah. And I think what I'm hearing also is all of those things you just talked about, the con use, the various meetings, the demos, may have very well informed that final rule and that decision not to go with network. And none of that is reviewable by the public, and yet it happened. And at the same time, if I recall correctly, Jonathan, there's a pretty big door left open in the final rule that basically says, and I'm paraphrasing here, network is not off the table. So this idea that we've got a final rule, it's broadcast, maybe that's good for you right now, but what about tomorrow when all of a sudden there's these new policies that start rolling in and they pick up where they left off? Is that a fair kind of characterization of some of the concerns that you have? I'm trying to best understand them.
Yeah, from a network, I mean, yeah, the network can still come back on the table at some point in the future, potentially maybe as an option primary to like standard ID. One reason why is competitive intelligence. You're trying to prevent your competitors from just actively gathering intel as you broadcast, right? As well as also for safety. I know some people that were potentially flying in maybe more sensitive areas, they'd be afraid to have their drone either shot down or themselves robbed. So they might want to actually have a network. So there's maybe some safety arguments also why that might come back. But we don't fully know how that's coming back and what manifestation, as well as we haven't seen how well the FAA is going to be treating the recognition of future CBOs, right? Some nonprofit wants to go get a CBO. Are they going to make it really difficult on the next guy? So there's going to be a de facto CBO, and how difficult is it going to be for those CBOs, how many ever there are, or educational institutions to obtain FRIA designations? How difficult will it be for the equipment manufacturers, for the aircraft, as well as the broadcast module ID companies? How hard will it be for them to actually go about obtaining this type of approval from the FAA so we can actually go and lawfully fly? So we kind of have some understanding there, but we don't fully understand how bad it will actually be until these aircraft actually start having to go through the certification process, and then those regulatory costs that are going to be imposed onto the manufacturers, right, through getting all this paperwork. That's going to be then passed on to the actual users themselves. And we don't know what that regulatory cost is going to look like. Is it, the FAA is kind of selling it this, but when you actually dive into the economic and impact analysis, you actually see it's far greater. Like they cherry picked that whole $40 remote ID from France unit, right? But they didn't pick the next one up, which is the one would probably actually use, which was like 100 and something euros. Right, which blows out, I forgot how many millions of dollars now that puts it over. So they cherry pick that. Don, are you gonna solder in some remote ID into your drone? Or are you gonna buy one of the stick-on ones? You'll probably buy the stick-on one, which is the more expensive one. They picked the one that you can just solder it. I'm like, come on, guys.
Well, and if I was Tyler, I'd want neither, right, Tyler? Right. Because your little drones that you fly as part of your hobby can't fly well with something like that attached. Is that part of your concern?
Yeah, I absolutely, right. I mean,
yeah.
if we add anything to our drone, it is gonna completely change the experience. Yeah.
And so then you're stuck with this FRIA, which we already talked about, and we really don't know what that is. I'm looking at Scott Schofman's comment again here. He's anxiously awaiting the advisory circular about, around FRIAs and CBOs, which are community-based organizations, are the ones that can apply to have the FRIAs designated. So let me throw this one out. Yeah, and we probably maybe have 5 more minutes. So if you guys have questions, please dive in now. I don't want to go more than 60 here. It's probably more than I wanted to do, but this is so amazing. I think it's really
I
important
couldn't
to
stop.
dive
I'm sorry.
into.
We had to
No,
go
I couldn't
further.
either. I mean, I think thank you guys both for taking this time and giving us your thoughts here. So wait a minute, what was I saying? Oh, how would you respond to people that would argue then, hypothetically, even the FAA, that would turn around and say, your lawsuit isn't ripe because this isn't really done. We haven't created these policies. You actually have no direct impact. It hasn't been implemented yet. How do you respond to that? Because I've actually heard people say that when they heard about the suit.
Oh yeah, I mean, the ripeness is primarily there. I have a good answer to that, but FA might be listening, which might clue them into something. But
I understand.
I have a really good answer for that one. But
I'll just say that is definitely on people's mind. It's like, we're concerned about what we don't know yet. We definitely know possibly from what you're telling us anyway, Jonathan. And I think, Tyler, you said a lot of these documents are up on your website. I think Mike dropped that in the chat. If you all want to look at those documents yourself, I always say go to the primary sources, read it for yourself, make your own decisions. I think we've heard there were some things that you got through the Foia that nobody else has until now because Tyler just posted it. And why was that not part of the public record? So let's talk next steps. What is the next step in this process, and what might the timeline be for it? What do we have to look forward to?
Yeah, so we have some more paperwork that has to be filed by April the 15th, and then some more by April the 30th. The court hasn't given us a date on when we need to have our briefs due by, so we're still waiting on that. But we already have a lot of our arguments and everything we've already worked out. And you're probably the rightness and a lot of these issues, and I think what a lot of people are trying to get at is trying to figure out the strength of these arguments. And obviously, we can't start throwing down the ace cards yet. I mean, Tyler's seen what we worked on. I mean, Tyler, how much stuff was there?
I'll say that this is a very significant investment for myself and my business. And if I was not confident in our ability to put forth a strong case, then we wouldn't be doing it.
Understand. So at some point along the way, Jonathan, arguments will happen, briefs will be filed, arguments will happen. Do you know if those would be live streamed, just given COVID? Are courts doing that? The DC Circuit Court of Appeals?
I don't remember off the top of my head. I mean, you can go back in time. Well, even if it's not live stream, you can listen to them. They have recordings for the DC Circuit Court of Appeals going back years. I mean, Taylor's stuff's all on there. You can go and listen to those in the oral arguments. So you can also kind of try to figure out, because you have like a 3-judge panel, right? And you'll try to figure out like, hey, this judge, what are the 3 judges that got assigned? Have we actually scoped out the judges currently in the case law? Yeah, we have, and so that way we can maybe make more predictions by saying, hey, this judge, which had this case previously. So we can, we can actually look at that. And then you can also kind of figure out what they're doing just based upon, well, I guess you guess, right? Can you really make a final call? But that's what social media is for. It's basically all is to get around on sometime at night and be like, let's talk about something, because we got to talk about something. What do you think about that, Tyler? You sound like you didn't like it,
Well, let me end with this one final question then, which is, what do you hope to achieve, right? Because there are people out there, running scared, like, oh, RID, that was going to be the keystone, the foundation to unmanned traffic management. It's the key to beyond visual line of sight. That's what we keep hearing. And we still don't have anything on BV loss, right, other than waivers to work through. They're just going to blow it all up. So what are you hoping to actually achieve in a positive way out of this endeavor? Because you clearly,
Sure.
Like you said, Tyler, you invested your time, you invested your money. So what do you want to see happen?
Yeah, totally. I'll kind of say in 2 ways. First way is just like how I describe it to my friends. I want little Mikey next door to be able to take his air hogs out, go fly it in his backyard with his dad, and not have to worry about plugging in any module to broadcast your salute, broadcast who he is and what he's doing, or connect to some network, or have to pay for that. That is put really simply. But on a more like official kind of stance, I'm hoping that we can let our hobbyists, whether they be FPV, model aviation, commercial, or what have you, continue to operate in a safe manner as we have been for many, many, many years, without additional regulatory oversight, which is unneeded and provides no additional benefit to the American people.
Okay, wow. Just wrapped yourself in the flag there. Good on you, and very, very well said, Tyler, for what you're trying to do. So, be interesting to see how this all plays out. Jonathan, did you have anything you want to add before we wrap up?
Not really. I mean, stay tuned, right?
Yeah, stay tuned. And that is, I misspoke. This is my last question. How do we stay tuned? How can we keep up to date on what is happening?
Yeah, totally. So there's a couple different places that I'm posting updates. The first of which, and I'll be remiss if I didn't mention it, is our GoFundMe page, which is helping to support this effort in a big way. And we're also posting regular updates there. So if you just Google Save FPV GoFundMe or RDQ versus FAA GoFundMe, it should be the first thing that pops up. And we'll be posting regular updates and timelines and any major things there. Additionally, if you go to Race A Quad's website, at the bottom you'll see some links, and one of them is for this case, and that is where you can find links to the Foia documents, our petition that we filed, any videos that we do, any documents that we write up, so on and so forth. And then I know John is doing a lot on his website as well, right?
Yes. Yeah, I have some stuff on my website as well.
Okay, awesome. And I still am a trained lawyer, a licensed attorney, although I'm not practicing right now, and I don't represent Interdrone. But I'm gonna just say, 2 seconds. Obviously, the opinions expressed here, right? They don't represent those of Interdrone. They don't represent P3 Tech Consulting. That's my company. We're hosting this podcast to be informative and inform the public as to what's happening with this lawsuit. So thank you so much, Tyler. Thank you, Jonathan, for taking the time to explain, what it is you are concerned about and what it is you hope to achieve. Best of luck, and best of luck to everybody, honestly, because at the end of the day, we all just want to elevate the drone industry, and we want kids to be able to fly. We want adults to be able to fly, and we want the airspace to be safe. I think we all share those common goals. So thank you very much. I think that's it. For those that follow Drones at Dawn, remember there will be a special podcast this Saturday. We're coming at you live from the Wings Over the Rockies Museum, the Women in Aerospace event at 1:15 Eastern. So we hope to see you this Saturday. And if not, we'll see you Monday with Hernando White and Black Girls Drone at our normal time and place. So that's it for tonight out here. Have a great evening.
Thank you, everybody.
Thank you.